Hello, my name is Robert Sterne, and I'm a partner with the law firm of Sterne, Kessler, Goldstein Fox in Washington, D.C. My video here is who is the perfect patent office litigator for the new contested proceedings under the America Invents Act, specifically the inter-party reviews and the covered business methods that went into effect on September 16, 2012. As an attorney who's been extensively involved in the reexamination process for the last 10 years, and now with these new contested proceedings, I am often asked to describe who is the perfect person to be the litigator in these new contested proceedings. So let me give you my very candid appraisal to this important question. First of all, it is important to know that the Patent Office, in the rules that they promulgated for these new contested proceedings, decided that you needed a registration number to be a practitioner before the Patent Trial and Appeal Board in these new contested proceedings. However, attorneys who are not registered patent attorneys like myself can appear as the lead counsel in these new contested proceedings using what is called a pro hac vice petition filed with the PTAB. And there have been quite a few of these filed in the first wave of contested proceedings that have been filed since September 16, 2012. And in practically all cases, these pro hac vice petitions have been granted. So in effect, an attorney who is not a registered patent attorney can be the lead attorney in these new proceedings. So that reaches the next question of which of the candidate groups that have been advanced is the perfect person or perfect group to select from. Now, what are these groups? Well, first, we are told by some that attorneys who are experienced with what is called interference practice at the USPTO are the ideal candidates for this new role. This is a very small group of attorneys who handled these very complex and frankly scary proceedings for the various parties involved that occurred at the Patent Trial and Appeal Board's predecessor board called the Board of Patent Appeals and Interferences over the last 100 years of the U.S. patent system. And oftentimes these interferences involved chemical inventions and not the electrical inventions that we see many of the new contested proceedings are focused on. So it's a very small group of attorneys that have done these hyper-technical interference practice events. So that's one candidate group. The second group are the attorneys that have done a lot of the reexaminations in the last 10 years, before first the Central Reexamination Unit, and then on appeal to the BPAI, and then to the Federal Circuit. And that is my focus. And these are the attorneys that handled these reexaminations, whether they be ex-party reexams or inter-party reexams. And it was the inter-party reexams that was the predecessor for the new inter-party reviews that are being conducted now at the PTAB. So these attorneys are very familiar with this contested proceedings context, which is much more expansive in some respects and much more narrow in other respects than the interference proceedings that tried to determine the priority between two patent applications or a patent application and an issued patent. So that's the second group. The third group are the Patent Prosecution Counsel. These are the individuals that prepare and prosecute the patent that typically finds itself later in these new contested proceedings. The argument for this group is that these individuals already know the patent. They know the prior art, they know the invention, they know the parties involved, particularly the inventors and the inside counsel. These are the people that actually produced the very patent that is now subject to this review on patentability before the PTAB. So they would argue to you that they are the least costly alternative and the best positioned to handle these new cases. Then you have the trial counsel. Oftentimes these are very experienced trial attorneys who are handling a concurrent litigation in the district court or the International Trade Commission involving the very patent that is now the subject of this new proceeding at the PTAB. And so they argue that they know the trial history and they know the patent in suit better than anyone, and therefore they're the ideal candidate to handle these new proceedings. And last but not least, there is a group of former board members who were on the BPAI over the years who claim that they are the best people to handle these new proceedings as lead counsel because they understand the patent office better than anyone, and they have been on the prior board and therefore may know some of the judges and know just how these kind of organizations work best. My answer to all of these groups is, it depends. It depends on who we're talking about and what's at stake. Each group clearly has their strengths and their weaknesses in their argument that they're the best or the perfect litigator for these new patent trials. My experience is that you need a team. You have to have a composite team that teams up some of the very best attributes and skills and deep knowledge of each of these groups. Specifically, you need to make sure the team has a deep knowledge of the office practice and procedure. This is absolutely essential. And you also, and this is very important in my experience, need to understand that it's the new proceedings that were filed around September 16th, 2012, that are forming the base of the case law and the decisions and the precedential and policy determinations that the board has made in the first wave of cases. And therefore, as I'm doing and my team is doing, we are reviewing every single one of these new proceedings to glean from them what we can understand as to how the PTAB is actually operating. And if the team does not have that deep knowledge of what's actually being done, you have a huge problem because you can't just read the rules. You can't just be an interference expert because interferences are old compared to these new proceedings. You have to know what's going on, as they say, on the ground. Experience arguing before the BPAI in, most importantly, reexamination proceedings, in my experience, is critical. The ability to argue before the board is entirely different, in my experience, than litigating before the district court judges or before the ALJs in the USITC. It's a different group, it's a different approach, and a different approach has to be taken to optimize your chances of success. As is the case in all litigation, and particularly in these new contested proceedings, you have to have a deep knowledge of the record and what's going on in the parallel litigations. And therefore, you need to work very closely with the trial team. But in addition, you have to have strong brief writing skills, particularly for the way briefs are written at the USPTO. And this is not exactly the same as you see in the district courts and the ITC, where more advocacy becomes the case. And there are very severe page limits in these new proceedings. You need insight on how best to prove your case and to attack the other side's case. That is critical because this is a new world and it's very uncertain how to prove your case and best establish your case in the very short time frame with the very limited amount of time and tools you have available to work with. The depositions in these cases are entirely different than you have in the district court and the ITC. These depositions in these new proceedings are essentially the cross-examination at trial of the witnesses. And the witnesses' direct comes in the form of the written record and the redirect in the depositions. You have very limited opportunity for proofs, particularly for non-obviousness and the nexus requirement. And therefore, you need to very, very deeply understand what you're up against if you're the patent owner's attorney when you're doing these new cases. And you need to understand that you're going to need to observe very precise conduct at these trials and in the hearings that the board has before the trials. It is not district court litigation. You have very tight timelines in these new proceedings, and don't expect you're going to get any extensions of time. So therefore, the team has to be robust and able to deal with this very fast-paced, unrelenting, unforgiving environment. So what's the answer to our question on who is the perfect patent office litigator? My approach is, and the one that I'm using, is a very carefully put together team that incorporates individuals who bring to the team all of these critical skills that I have just outlined. Well, I hope this helps you, and I hope to see you in one of these new contested proceedings in the future. Thank you very much.